Hello and welcome back to the second of the series on the Supreme Court. We're going to talk a little bit about Ashwander versus Tennessee Valley Authority and how the Supreme Court determines whether to hear a case or not. This is essay number 65 on page 366 to 367. It's a short case, and we're not going to brief the case. What we're going to do is talk in terms of the Supreme Court and the nature of the Supreme Court. The Supreme Court is not democratic. We really do not know what goes inside the court. It's again, the members of the court and what they tell us, but the press is not allowed inside the conference rooms of the court. All we have to go with is maybe some memoirs by justices in the past, but it's not liable for open meeting laws or any of these kind of things. So again, Justice Brandeis writes in this opinion, Ashwander versus Tennessee Valley Authority, some rules that the court tries to use. And I'm just going to have a short little presentation today in order to sort of show you how this is different than what necessarily a political organization would have, like the legislature or the executive. Brandeis starts saying, the court developed for its own governance in the cases confessedly within its jurisdiction a series of rules under which it has avoided passing upon a large part of all of the constitutional questions pressed upon it for decisions. What's Brandeis saying? He's saying we don't want to really answer constitutional questions. We are the Supreme Court and we are an appellate court and we do interpret the Constitution, but when we have a choice, we rather not. And so the first rule, the court will not pass upon the constitutionality of a legislation in a friendly, non-adversarial proceedings declining because to decide such a question, quote, is legitimate only in the last resort and as a necessity in the determination of real, earnest, and vital controversies between individuals. So, the first rule, there must be a case. So, if I'm the Senate Majority Leader or a congressman, and I go to the Supreme Court and say, can you tell me if this is constitutional or not, this law? The Supreme Court will not give you an opinion. If I'm the President of the United States and I say, hey, I want to do X policy, can I do that? The Supreme Court will not comment on it. One must have litigation. One must have a case. And that's why we talked about earlier how to brief a case. Because if you want to understand what the output of the Supreme Court is, then you have to understand how to read a legal case. Not what some commentator tells you, right? Not what some professor tells you. No. You have the power to read the case yourself. And that's what we're trying to do. And so the first law, or the first rule that Brandeis talks about is there must be a case. The second one, the court will not anticipate a question of constitutional law in advance of the necessity of deciding it. The court will not, right, answer a question without it being necessary. So the second law is if we can avoid a constitutional question, we will. So the necessity of the constitutional question. We are forced to answer that this law is repugnant to the Constitution, using Chief Justice Marshall's words, right? You goes on, it is not the habit of the court to decide questions of a constitutional nature unless absolutely necessary to the decision of a case. The third rule, the court will not formulate a rule of constitutional law broader than is required by the presence and the precise facts to which it is to be applied. Again, this is why facts are so important. So, right, if there is a constitutional question, it will be limited to the nature of the facts. So an interesting historical example would be Roe v. Wade. So Justice Blackmun wrote Roe v. Wade because Chief Justice Berger thought that Blackmun, being the counsel for the Mayo Clinic in Minneapolis for years and years, thought that would be a good, his expertise would be a good source for writing this opinion. None of the Supreme Court justices at that time thought that this was going to be an issue. Blackmun thought it was more a issue of doctor-patient privacy. And they were actually stunned by the pro-life movement that came after Roe v. Wade. So this whole idea of limiting the question, limiting the opinion to the facts, comes out of this idea that we're not going to have a constitutional question that is irrelevant to the facts of the case. The fourth rule, the court will not pass upon a constitutional question, although properly presented by the record, if there is also present some other grounds upon which the case may be disposed of. So like I said, in sort of rule number 2, right, necessity, also if we can find an alternative answer that we do not have to use the Constitution, we will use it. Okay, so again, this is just a made-up example, but you would have a fact situation in which my dog bites the mailman, and it is a federal question because the mailman is an agent of the federal government. If the courts can find some way that I can be punished or that my argument can be made without invoking the Constitution, they'll use it. Not a good example, but one that I think you can understand. The fifth rule, the court will not pass upon the validity of a statute upon complaint of one who fails to show that he is injured, by its operation. What are your damages? Right? You have to be damaged. What are your damages? If you don't have damages, then the court will not address the constitutional issue. And this, again, an example of this would be, if you're familiar with sports, they have the famous NFL is a monopoly. The USFL sued the NFL, this is in the 80s, and actually Donald Trump was a litigant in that case, and the USFL received $1 in damages, right? So if we had a case like that the litigants could not demonstrate that they were damaged, then the Constitution would not, the Supreme Court would not address any constitutional issues. The sixth rule, the court will not pass upon the constitutionality of a statute at the instance of the one who availed himself of its benefits. So again, if I benefited from this unconstitutional law and I went to the Supreme Court and said, this law is unconstitutional, the courts will not rule on it because I benefited from it. I have to be a litigant, and I have to have damages, and I have to use a case. I have to be in a case. These are all the conditions that the court uses. And the final rule, when the validity of an act of Congress is drawn into question, and even if the serious doubt of the constitutionality is raised, it is a cardinal principle. Cardinal, of course, means principle or primary principle of this court will first ascertain whether a construction of the statute is fairly possible by which the question may be avoided. So the last rule, of course, is that if we can find a way to interpret that law by Congress that was signed by the president, if we can find a way, right, we will avoid addressing the constitutional question. Now, what's interesting about this case is, what is the Supreme Court doing? The Supreme Court is saying, we are the referee of the Constitution. We interpret the Constitution only when we really have to. So, again, this sort of idea that justices make law, the idea that the justices, if we have a person who is pro-life on the court or a person who's pro-choice on the court, their personal political vision or perception will somehow permeate through their decision-making process. Well, if you look at the legal analysis, the legal thinking, not the political, and if you see and read this case, one gets the inclination that the justices really do not want to rule on these things. And why is that? It is because laws should go through the process of going Article 1, Section 7, right? Majority of the House, majority of the Senate, signed by the President, or 2/3 of the House, 2/3 of the Senate. The justices do not want to somehow impose on themselves, impose on us their vision of the Constitution unless it is absolutely necessary. Just like a good referee knows when to let the teams play. That's this case. And this is known as the Ashbury Rules. I look forward to seeing you again.